SJC-12362, Commonwealth versus Jose E. Colon.
May it please the court.
Why don't
My
you wait,
name
why
is-
don't you wait one moment
Oh, I'm
until we
sorry.
get settled? Okay, now, Ms. Perinsky, good morning.
Good morning, Your Honor. May it please the court. My name is Elaine Perinsky, and I represent the appellant, Mr. Jose Colon, who you know was convicted of first-degree murder. I've identified a number of issues for the court's consideration in the appeal. Three of those issues have to do with jury selection, jury deliberation, and I'll start with that. There was substantial evidence of juror bias in this case, which denied Mr. Colon the right to a fair and impartial jury. A number of the juries expressed fear of the defendant and bias toward him in that he was a gang member, even though there was no activity of gang membership at all in this case, had nothing to do with gangs. It all started with juror number 15, who said in front of court officers that she was afraid of retribution by the gang members if the defendant was found guilty, or she was afraid that he would stab someone else if he were found not guilty. Of course, that juror was removed, but before she left, she informed the court that others had expressed fear and concern about gangs. Juror number 1, so there was an individual voir dire conducted of the jurors to determine what was the extent of this bias. And I would suggest the extent was pretty high. Juror number 1, he checked to see if anyone was walking behind him when he left the courthouse. The prosecutor suggested that maybe this juror should be removed. So that juror was removed. Juror number 2 expressed concerns, but she said she was fine now. Juror number 16 expressed surprise that people were picked from her area because she lived down the street from where the alleged crime, or the crime, we can call it a crime, someone was killed here, that occurred. Juror number 3, the foreperson of the jury, expressed concern in the ability of them to know who we are and find us if they wanted to go after us after the verdict.
Ms.
This juror,
Ms. Perinsky, as it relates to these issues, I know that you have an issue about the defendant's participation or lack thereof as it relates to the voir dire. But putting that aside for a moment, the judge did conduct a voir dire. And when we look at a voir dire dealing with issues of impartiality, there's great deference to the trial judge who's taking into account credibility and demeanor, not just what's said, but the manner in which it's said. Why shouldn't that deference apply to the determination that the juror remained indifferent?
because I believe he got it wrong in this case. I don't know how he distinguishes juror number 16 from juror number 1, who just said he was checked to see if anyone was behind him, and juror number 16 said that maybe juror number 3, the foreperson, said maybe the people that the defendant might know will get us afterwards. And then she also referred to tattoos on his hands and jumped to the conclusion tattoos on his hands must mean he's in a gang. So I think the judge got it wrong. He let juror number 1 go, I suggest, because the prosecutor suggested it. The defense attorney repeatedly asked to strike the whole panel, which was denied. And also the judge stated juror number 3, again, the foreperson of this jury, that her fears were gone. But that's not what she said. What she actually said was, when asked whether she still had fears, I don't know. I think I kind of let that, I think I kind of let that, and then it didn't get the last part, but I don't know is I don't know.
Yeah, counsel, did anyone make a motion to change venue before trial started?
I don't believe so, but I can't say with certainty. I would suggest to the court, first I'd say there was no evidence of gang activity in this case, and the court did nothing to dispel that belief from these jurors once that all came out. The motive, there was nothing of gang activity. And I would suggest to the court that the right to an impartial jury should never be watered down, regardless of what you think of the evidence, the status of the evidence. That's a right to it that should never, ever be watered down. We don't want to get to a place where you say, well, this guy looks guilty, so an impartial jury is not that bad.
Can we jump to the
sorry?
process of how the jurors, how the voir dire was conducted? I understand that the defendant wasn't allowed to hear what was going on, or
Right.
wasn't allowed to understand what was going on.
Well, the judge said he can be present, but without ears. What that
Is that
means,
because of the interpreter?
I'm sorry.
Is that because of the lack of an interpreter?
Yes, that means the lack of it. So he's present without ears. This is a gentleman who chose to go sidebar during jury selection. So this is a gentleman who wanted to participate in his trial.
Did defense counsel agree to that?
I'm sorry?
Did defense counsel agree to that arrangement?
He eventually agreed to it, but the judge said right on that he was to be present without ears. Now picture this, that everybody's understanding what's going on but the defendant. So it was agreed that the defense attorney would tell the defendant that this juror was excused for personal reasons.
The judge did say, though, that he could tell his client whatever he wanted, right?
Well, he did, and
Whatever-
he didn't. What he stated to him, and I suggest that this is part of the prejudice, what he actually stated to him, give me a second here. I don't think that you are duty-bound to tell him that people are afraid of him. And then he said to him, are you going to explain the personal reasons? And the defense attorney said no. So what we have here is a judge basically telling someone, don't be honest with your client.
But
Don't
didn't he
tell him
didn't he
everything
later-
what's going on
But I thought he
here.
later said that he could tell him whatever he wanted, whatever he felt he was duty-bound to do. He should do.
Well, I mean, he said that and said that he's not duty-bound to do that. I don't think you're duty-bound to do that. So I think there was a strong suggestion of, don't do that.
Yeah, but
And
the defense
judges-
attorney agreed that he didn't have to tell him everything, and we don't have this on an ineffective assistance claim right now.
No, we don't.
So the issue really is what's the consequence of the defense attorney agreeing to the procedure?
Well, I think you have the consequence of a defendant not being fully aware of what was going on in his trial.
No, I appreciate that. I'm saying, what do we have before us without an ineffective assistance claim and an ineffective assistance record, when we have the defendant excluded from understanding what's going on because he loses the benefit of an interpreter? I understand that it doesn't make sense and that he should have been participating in everything, but we have the defense attorney agreeing.
Well, but we also have a defendant who was clearly denied his right to be, in a sense, present at a crucial part of the trial. And there is case law that says juror bias is a very consequential matter in this case.
But we have unpreserved error, and we're looking at for a substantial likelihood, right?
Let's say-
A substantial likelihood of a miscarriage. How is it a substantial likelihood of a miscarriage of justice then?
I would say anytime a defendant is not apprised, as suggested to by a judge, not to be told what's going on in his trial, that's a substantial likelihood of a miscarriage of justice.
Did you file a motion for new trial based on ineffective assistance of counsel on this ground?
No, I didn't.
So what's the prejudice since the defendant, after the voir dire hearing, asked for a mistrial? I mean, what more could have happened if the defendant had heard everything than a motion for a mistrial based on the jurors' answers?
Well, perhaps we wouldn't be at the level of a substantial miscarriage of justice if the client was made aware and told, presumably would have told his attorney, object to that.
I'm
So-
sorry, but I thought the attorney did move for a mistrial at the end of the voir dire.
he
and
did
said,
move
and
for
so
a
we need to
mistrial.
remove the entire veneer. So I don't know what more could the attorney have done than to say, we need to remove the entire veneer and start over. If he had heard everything and if he had been appalled by what he heard, then he would have arguably told counsel, you should ask for a mistrial, but he already did move for a mistrial.
Can I point to a specific, what prejudice, other than it's a substantial right of the defendant to be present at crucial proceedings?
But-
And that it's fairly offensive that everyone can understand, but they take the interpreter away so the defendant can't understand?
But I mean,
I can't
I
point-
tried many a case involving, in criminal cases, in which defense counsel chose to not bring the attorney to sidebar during the individual voir dire of jurors during a regular voir dire. We don't consider that to be structural error because the defense counsel, for whatever reason, said, I'm not going to bring my client to sidebar.
But my guess is that you don't find many where the judge suggests that you don't tell your client what's going on. And the reason the judge gave in this case is that he didn't want to whet the appetite of the defendant to instill fear in people. Now, this is a defendant, presumably staring at people with a mean stare or something. And this is a defendant, which the defense attorney said, just sat at the trial, looked forward, didn't look at the jurors. So there was no evidence of this defendant trying to instill fear in anybody.
I think what the questions are getting at, though, is not whether or not the procedure was appropriate. The point is that this is not considered, unless you have a case I don't know about, structural error. So where is the substantial likelihood of miscarriage of justice? You've already established why it shouldn't have happened this way, and you've done it well. But if it's not structural error, it has to be a substantial likelihood of a miscarriage of justice, and I'm not seeing the argument as to how it is.
Well, I think it's definitely, like I say, I can't pinpoint that but for this, something would have happened, but it's a slippery slope to go down when attorneys are being suggested not to tell their client what's going on, when translators are taken away at certain parts of the trial.
But we don't really know what because there wasn't a motion for a new trial or an ineffective assistance claim, we don't really know what the attorney communicated to the defendant, do we?
Well, when he said to him, are you going to explain the personal reasons? He said no.
But we just don't know exactly what he said or what the back and forth with his client was, right?
You're correct. We don't exactly know. But I would suggest to the court, well, maybe I'll go on to the third argument of jury voir dire in the beginning in selecting a jury, which I suggest led to the fiasco at the end of trial, where he ended up with a partial jury and not an impartial jury. The defense counsel requested individual voir dire because of different, well, the prosecutor calls ethnicities, but based on different race. The two alleged perpetrators, even though one defendant was charged in this case, the other one was also charged, but there was a no bill on his case. But there was suggestion that there were two perpetrators in this case, and they were both Hispanic, and the victim was white. And Counsel requested that individual voir dire be given in this case, but because of racial bias, and that there was a substantial risk of bias, which actually was shown in the jury deliberation. It was right under the surface. And individual voir dire might very well have uncovered that if a judge showed more caution.
Now, you argued that there should be an obligation of every judge where there is an ethnic difference between the victim and the defendant to ask the jury about that. You did not suggest that they were of different races, did you?
In my brief?
Yeah.
No, I mean, he's Hispanic and,
Okay, but I mean, Hispanic is not a race, and there, of course, are Latinos who are black and Latinos who are white and Latinos who are brown. So where do we take this? I mean, if we were to, let's assume we were to accept your proposition that every time there's a difference in ethnicity, you need to ask the jury about it. Would it be limited to Latinos or Hispanics, or would it be a German American and a Asian American, or a German American and a French American?
well, I think in thinking about this, we can't ignore the reality of the world, or the reality of where we are now, that there is substantial prejudice against Latinos and Hispanics, that there is stereotypes of Latinos and Hispanics. Like the juror said, he had tattoos, he must be in a gang. If you see a white person with tattoos, you don't necessarily jump to, he's in a gang. There are stereotypes on TV. There are stereotypes, I won't mention his name, but from our own government. So there are stereotypes about Hispanics. There's substantial prejudice that exists in the community.
But I thought the question that the attorney wanted to be asked was the fact that we have a white victim and a Hispanic defendant. Would that affect your ability to be fair?
Right. So he's
but
trying to uncover bias in people against Hispanics.
Okay, but I gather and I from the briefs, I've not gone back to the record, that the judge essentially said, no, these two individuals were friends. There's no indication that ethnicity played any particular role in the killing, and therefore this is not the kind of case where that question would make sense.
I think the jury proved him wrong. Right under the surface, like I said, she saw a tattoo, she thought he was a gang member. They thought he was going to follow them and stab them or get other people to do that. It was right under the surface. And when you have it was two Hispanics that were, one, like I say, one was no build, but the evidence showed that there were two people. One person, Cruz, who allegedly brought the knife to the scene, and the defendant. So there were two Hispanics and the victim was the white person. So I think there was, and there's no real evidence that they were friends other than they went out drinking that night.
Was there a question requested as to whether or not the prospective jurors had any bias against Hispanic people in general?
No, I don't believe, in the questionnaire, no, I don't.
Well, was it requested
Any
by the...
bias at all.
Was that a question requested for individual voir dire?
Yes, I believe it was.
So that's what I'm trying to separate as Judge Budd. There's a difference between saying white victim, Latino, or Hispanic defendant versus saying, do you have any feelings about Latinos or Hispanics that may affect your ability to be fair? That may be asked regardless of who the defendant is. It could happen, I mean, the victim, it could be even with a Latino victim. Was that question asked, or was the focus on the difference between the ethnicity of the victim and the defendant?
You mean, was it asked in the questionnaire?
Was there, or did the defendant ask the judge the question that Justice Budd is asking about? Do you have any feelings?
I have no memory of that being asked, no. In the trial
requested.
transcript, no. I have no memory of that being, yeah. But like I say, we have to look at the reality of the world. I mean, and if you just look at race, then you're just looking at skin color and not the reality of the world, that there is prejudice, there's stereotypes, and that comes up. And it just does. And that's something we can't ignore. I see my red light is blinking, so I will rest on my brief for the other item.
Thank you. Ms. Lazar, good morning.
Good morning. Ellen Lazar for the Commonwealth. This court should affirm the defendant's conviction because none of his claims of error warrants a new trial. Regarding the impartiality of the jury, Judge Tucker properly declined to strike the entire jury after questioning every juror individually, excusing 2 jurors who were possibly not impartial, and determining that the remaining jurors were impartial. As the court is aware, and as Justice Lowy noted, determination of juror impartiality or determinations are given great deference by this court because the trial judge interacts with the jurors face to face and can assess their demeanor and their tone and facial expressions and other things that are not reflected in a transcript. The judge here struck the first juror who had expressed fear because she lived near the crime scene and she had a very distinctive name that she was concerned that the defendant would have heard during impanelment. He also struck a juror who said that he was impartial, but struck him out of an abundance of caution because the juror also said that he was checking that he was not being followed when he left the courthouse. And I believe this was a juror, too, who said that he lived very close to the crime scene. The only other juror who said that she had been concerned the day before, the juror in seat 3, also said during the voir dire that she had no concerns or fears of continued jury service at that time. And the judge, who again was looking her in the eye, was entitled to take her at her word.
Wasn't the procedure problematic with God and the interpreter?
Yes, Your Honor. But I believe that it doesn't warrant a new trial. The process that was used, where defense counsel was at sidebar with the judge and the prosecutor and the juror who was being questioned, and then the defendant sat at counsel table, and counsel updated the defendant in between the questioning of each juror.
I think he didn't update him accurately, right? Because he was going to do what the judge requested, which was not to let him know what was going on. It was going to be just for purely personal reasons somebody would be dismissed, not because of fear.
In the end, the judge did say to the lawyer, you tell him whatever you think you're duty-bound to tell him.
Right.
And the attorney, throughout the discussion, and it was a long dialogue about how this process should be conducted, the attorney's concern really was that the defendant be in the courtroom. The attorney never expressed any concern about the defendant, the juror's statements being translated.
What about
to
why not an interpreter? What happened to the interpreter?
The judge instructed that the interpreter not.
That was not right, right? That was
No,
not, that was
it
not right.
wasn't. But the process that was used was suggested by defense counsel, and I would say that it's the equivalent of waiving the defendant's presence at sidebar. Other than the fact that there was an interpreter in this situation, that's exactly what it
The judge
was.
brought this process up, not the defense attorney.
Yes, that's what I'm saying.
The judge is the one who initially raised his concerns that if the jurors knew that the defendant could hear them or understand them, then the jurors might not express their true feelings. However, defense counsel did not disagree. He says repeatedly, I have no problem with the court's direction that if anyone is excused, it's for personal reasons. I understand your concern. I agree with the court. I'm not duty-bound to tell him that.
But I don't think, my memory at least was, it wasn't the defense attorney who said, let's do this procedure where you're not present. It was the judge said, he's not going to have ears or something like that.
So the judge was the
And
one.
maybe the defense attorney didn't object or should have objected, but didn't.
Yes, the judge was the one who initially said, he can be here, but the interpreter won't interpret. But I think also that had to do with the fact that at some point in the discussion, it seemed that the judge and the attorney were not understanding each other, that the attorney thought that the judge was saying that the defendant could not even be in the courtroom, which seemed to be what the attorney's concern was. So finally, the attorney said, so you're saying he can't be here? And the judge said, no, he can be here, but without ears, meaning the interpreter would not interpret.
As I read the, at least one part of the transcript, the judge offered that the interpreter could be there and would be speaking through a piece of equipment, and the defendant would hear it through a microphone. This is in volume 2 during the jury selection. Was that not, did that occur, or?
So that is the way that the jury selection occurred. The defendant wanted to be at sidebar or at least informed during jury selection, so that is how that occurred.
But he could hear through the earphones, is that correct?
He could hear it through the earphones, and the interpreter was interpreting it during jury selection in volume 2. This was during deliberations.
Okay, later on in volume,
8.
in the end of the situation.
Right,
All
when
right.
one juror expressed her concerns, and then they did the individual voir dire of the
Right.
deliberating jurors, and that is when the judge is the one who suggested that the interpreter not interpret.
Isn't it
But-
important that the defendant know that the jury is frightened of him? That seems to be a critical thing to inform the defendant about, isn't it?
Well, I think that it was the attorney's choice, or the attorney agreed with the judge that he did not feel that he needed to tell the defendant that the jury was fearful of him.
But isn't he wrong on that? Shouldn't the defendant know that he's got a jury that's scared of him?
Well, first of all, we don't know what the attorney told the defendant. As I said, in between the questioning of each juror, the attorney returned to the table, updated the defendant on whatever he told him, and again, the judge left it with counsel, okay, you tell him whatever you feel you're duty-bound to tell him. Secondly, it's the Commonwealth's position that no jurors who deliberated were fearful of the defendant. The 2 jurors who expressed fear, one who even said, well, I can be impartial, but said he was looking over his shoulder, were excused from the jury. The one remaining juror who said, well, I had some concerns yesterday, but essentially I let that go, she explicitly said, I do not have any concerns or fears about continuing with jury service.
But the process was one suggested by the judge. And doesn't the judge have responsibility for the fact that this was really a flawed process with respect to taking away the interpreter?
So the judge
It's
is the one.
fundamental error to do this, I think.
I'm sorry.
I think it's fundamental error for the judge to have done that.
So assuming that it was error, yes, the judge is the one who said no interpreter, although defense counsel, again, did not object, and defense counsel was the one who suggested the procedure that ended up being used, where counsel was at sidebar, the defendant was at the table, and he updated
The
him.
best he could do.
But
Absent an interpreter, that was
so
the best he could do.
assuming that there was error, the question is, was there prejudice to the defendant? And he does not claim any prejudice. He makes no suggestion whatsoever about how the process would have differed had it been interpreted to him, or how the outcome of the process would have been different had it been interpreted to him. So assuming that there was error, this court has repeatedly held that a defendant's exclusion from an individual voir dire, even of deliberating jurors, does not necessarily require reversal. And one of the questions is, was there any prejudice?
How would we know if there was prejudice?
Well, the defendant is not suggesting any.
But how would we know if there were? I mean, this is like an impossible situation for a defendant, don't you think?
Well,
How would you prove prejudice?
I
Unless
feel
the jury
like
came back with a verdict of not guilty, in which case, okay. But I mean,
Right.
here he's convicted of first-degree murder.
I think that the issue really is, did an impartial jury deliberate and come to a verdict? And it's the Commonwealth's position that they did. The defendant claims that he was deprived of a very important right, and that may be so, but the court still, in the cases analyzing a deprivation of this exact right, has required a showing of prejudice in order for it to be reversible error. And here, not only is there no showing, there's not even an allegation of any kind of prejudice. And as Chief Justice Gantz noted, after all of this was over, counsel moved for a mistrial. He moved to strike the entire jury. That was denied. there's no suggestion that anything would have been done any differently had the defendant been hearing exactly what was said. And again, we don't know what counsel told him. He did update him in some sense or another. And so where there's been no suggestion and certainly no showing of prejudice, it's the Commonwealth's position that even if there was an error, it's not reversible error.
What distinguishes those jurors who were removed from those jurors who were not? What's the standard that a judge must use in deciding whether or not some degree of fear of a defendant warrants their removal from the jury?
Well, I think the ultimate issue, of course, is are the jurors impartial? And so if he believed that the two jurors who he struck because of fear perhaps would not be impartial in rendering a verdict because they were either afraid that if they acquitted the defendant, he would be out on the street, or if they convicted the defendant, someone would get them. No other jurors expressed any fear or concerns about deliberating. And the judge, again, who had the opportunity to question every one of these jurors face to face, made determinations that they were impartial, and that's something that the court gives great deference to.
How many jurors were present when the jurors who were afraid were talking about it? Was there an instance where everybody heard what the jurors who were afraid was saying?
It was one juror who was talking to a court officer. It was in the jury room, I think, on the first day of deliberations as they were leaving. The alternates were not in the room, but all of the other jurors were in the room.
And they heard it?
Most of them heard it. When they did the individual voir dire, the judge asked the jurors whether they had heard it, and most, if not all of them, had heard it. Some of them just sort of thought nothing of it or dismissed it. And again, there was only one juror who said, well, I had some concerns yesterday, but right now I have no fears, I have no concerns, I've let that go.
How long was it after this that the jury was returning a verdict?
After the two jurors were struck and two alternates replaced them and the jury were sent out to begin their deliberations anew, I believe it was a little bit over an hour before they came back with their verdict. Regarding the defendant's claim about examining the jurors for racial or ethnic bias, Judge Tucker correctly declined to do that because the defendant and the victim were not of different races. As the court noted, the defendant is Hispanic and the victim was Caucasian, and these are different ethnicities, not different races. So questioning about ethnic bias is not required, especially where there was no suggestion anywhere in the record that ethnic bias was a motive for the crime. So unlike in the case with racial bias, there's not an assumption that there's a reasonable possibility of bias due to different
Now,
ethnicities.
I may be mixing this up again, but I thought I read in the beginning of the voir dire that there was a juror who was concerned about having prejudice against somebody who was Hispanic. Is that?
I'm sorry, I don't
Okay,
recall that, Your
Let me see if I
Honor.
can find that.
What I do recall is that the defendant asked Judge Tucker to conduct an individual voir dire of each juror for ethnic bias, arguing that the jurors may assume that the victim was killed because he was not Hispanic. And the judge declined to do that in the circumstances of this case where there had been no showing that there was a reasonable possibility of bias based on ethnicity, because there was no suggestion in the evidence that that was any sort of motive for the crime.
Was any question, the defendant ask that the jury be asked whether they have any feelings towards Hispanics that would affect their ability to be fair?
Yes, yeah. Oops. I found it's at 240. Well, I'm not supposed to answer questions.
Thank you.
Volume 2, page 40, the court asks, juror number 6, you said yes to the fact that the defendant is Hispanic would interfere with your ability to be fair and impartial. Why is that? And juror 6 says, I don't know, I just have, it's just my perspective. And the court says, I'm going to excuse you. So,
Yes.
Okay, but that was in response to a juror volunteering it. Was it a question that was asked of all the jurors?
I believe that it was. Not the question about the fact that the victim and the defendant were of different ethnicities, but a question generally if the jurors were biased against Hispanics.
And was it asked collectively or was it asked individually?
I believe that it was individually. I'm not precisely sure, but my memory is that it was.
Is this a case in which there was individual voir dire of all jurors or only of those who raised their hand?
I think that there was individual voir dire of all jurors. And if the court has no further questions, I would rest on my brief for the remaining claims.
All right, thank you.
Thank you.